Hi, I'm Marc Stevens, author of Government Indicted. The website, of course, markstevens.net. Radio show is on twice a week, Saturday from 4 to 7 Eastern Standard Time on LRN.FM, and also Wednesday, commercial free. So definitely tune in for that. We had a great one just a couple, I guess 2 days ago. We're doing this on Friday. And I want to talk a little bit about this success stories because this is we had this for a while, but I'm finally getting it posted. So it's the first one posted for 2017. So it's been a few weeks since we've had one, but we've had a lot. We've had a lot. If you go through this, it's extensive. It is that bowl of death again. Don't know why we're getting that, but it is fairly extensive here. You can go back at least 4 years. We've got quite a few of these, everything from taxes to traffic and drug charges. Yes, even drug. I think we went past before Joe in Hawaii. So we've got a new one to add to this. So let's get right to it. There is the actual ticket. And so maybe what I can do over here is I can blow that up a little bit more. Probably too much. That's good. And so this is in Hawaii there. There you go, state of Hawaii. And some of the information. The important thing here is that this is for a violation of the traffic code. See right there. Driving a motor vehicle without a driver's license. It says up here, operator license number. There is none. This is very, very important to this because it is not disputed that there's no driver's license, okay? No driver's license. So a police officer is claiming he saw this individual happen to be a minor. And thanks to Sean, of course, for providing me this documentary proof for the website. But the officer believed that a minor was driving a motor vehicle and that the laws were applied, and that he had jurisdiction to do a stop, and that the laws applied, and not only gave him jurisdiction, but jurisdiction to the court where he filed this particular ticket. And Sean did what we always do. We always filed a motion to dismiss and a discovery/Brady request. And what we're looking to do, and I'm not hiding this, this is, the motion to dismiss is based on the prosecution's lack of evidence to set forth a legitimate claim, a legitimate charge, because they're only assuming that the constitutional laws apply. They don't have any actual proof of that. And so that goes to territorial jurisdiction and personam jurisdiction. It's an element of the charge because he's accused of violating the code, as you can see right here, HRS 286-102. Code violation. So there was a few other ones. There's also, you can see down here, there was the heinous crime of not having insurance. But this is the big one here. This is okay. So from what Sean told me, not only did he file the motion to dismiss and the Brady request, but the day he faxed the prosecutor a copy of the discovery request, he got this. I can't blow this up anymore because it's not a very good copy. It looks like he took a picture with his phone, but you can see it's the District Court of the Third Circuit, South Kahala Division. It is involving a minor, so I did black out and redact that. But what we have here is a motion for nolo prosequi, which is, no prosecution. That was filed. It was X down here for with prejudice. This is very significant. It's the now comes the state of Hawaii, which is a DBA for E. Britt Bailey. There is no such thing as the state of Hawaii. That's why he's saying, I hereby move this court for nolo prosequi with prejudice. The state, meaning Britt Bailey, is unable to prove this matter beyond a reasonable doubt. And then the judge, Kanani Laubach, signed it. That's the judge of the above entitled court. So it is approved and ordered. It was dismissed with prejudice. With prejudice, which is great because, I don't have it up there anymore, but with prejudice means that it cannot come back. It's basically like a determination on the merits and is res judicata, which means the matter has been determined and you cannot revisit it. Now, this particular one, it was not done on the merits. This was dismissed with prejudice because it didn't have any merit. The state is, Britt Bailey is unable to prove this matter beyond a reasonable doubt. Well, first, a big congratulations to Sean for helping the minor to get this bogus ticket thrown out. And I appreciate being able to present this. But I want to break this down a bit because there are some significant things here for the critics and for those who are healthy skeptics who would be like, well, yeah, these tickets are thrown out all the time. Big deal. I mean, and I think there was another ticket that was filled out. There was more than 2 charges here, and they were all just traffic. The thing to keep in mind here is that this is okay. Let's address this like I do in the article that goes with this. That someone to say it's just too much trouble. Is it really too much trouble? See, what we're talking about here is a statute, okay? And it's what they call a strict liability statute. There's no intent that has to be proven. For them to get a almost guaranteed conviction, all they have to do is show proof, which is from the DMV, that there was no driver's license and that he drove without a license. They've got this guy over here, officer whatever, to testify to that. Is it really too much trouble to get a DMV document showing that the defendant, the alleged defendant here, does not have a driver's license? No one's disputing that. That's not being disputed. They're not disputing that he was in control of the vehicle. Is it then too much trouble to have the police officer come into court and get paid to testify for a few minutes? All they have to do, if there is proof that the Constitution and Code apply, the only thing they need to do is testify he was driving without the license and show the DMV record. It's a standard thing that they do in these cases. If they're not being challenged on the foundation of the case, which is what we did, which is what we do. That's why you can look here and you can see all these success stories. Even here, Wales, for heaven's sakes. We have 2 of them in Wales just last year. So, and here we have the motion to dismiss explicitly granted. We have all these tickets getting thrown out because we are making that particular challenge. Is it really? So I don't buy this thing that it's too much trouble, only in the sense that it's too much trouble to falsely prosecute somebody. But even that doesn't hold any water because they do it every day. Every single day they get away with that. So what I want to do is I want to address this idea, because some claim that they don't have to prove the Constitution and Code apply. And that is, I've addressed that in other videos. It's a claim from the police officer. It has to be proven beyond a reasonable doubt that the laws do apply. Now, they vehemently argue that they do apply, but they can't present any damn proof. They don't think they have to. But you see, there's a problem with that because, and I think this goes directly to why why they filed the dismissal. They wanted to dismiss. The day he faxed them a copy of what he filed, they filed a motion to dismiss the same day. Well, Mark, that could be a coincidence. Yeah, but they already had the motion, and it was already mailed to them. So you can't ignore the evidence. At least the rational can't. So here, the evidence is the motion to dismiss the Brady request, and he dismissed with prejudice. So not only, and I'll get to the Brady request in a second, but you have to, you can't underestimate, look, they didn't throw it out they didn't want it thrown out with prejudice. They wanted it thrown out Let me say that again. They didn't do it without prejudice so they could refile if they somehow found this evidence that they needed that was being requested. No, they did it permanently with prejudice, knowing he doesn't have the license, he's not disputing it, and he still is not going to get the license. They still stated here they cannot prove it beyond a reasonable doubt. Well, logically, we know that they can if they have proof and if it's so obvious and self-evident that the Constitution and laws do apply because he's physically in Hawaii, then they have the evidence necessary to prove beyond a reasonable doubt that he operated that vehicle or drove that vehicle without the license. It's not in dispute. So what is it that they can't prove beyond a reasonable doubt? They can't prove their laws apply. And even you critics know that that is true. You know it's true because you excuse it saying it doesn't have to be proven. You know it can't be proven beyond a reasonable doubt. It can't be proven to any degree because it's pure speculation. It is purely an assertion, fallacy, proof by assertion. He said so. He said so. They said so. It's true because I said so. You know that. But thing is, that doesn't excuse the contradiction and in the rules because the rules require certain things. So we asked the Brady in the Brady request, Brady material. Brady disclosure consists of exculpatory or impeaching information. Okay? That is material to the guilt or innocence or to the punishment of the defendant. Impeaching evidence. Now, there is absolutely no rational dispute that the police officer, okay, I'll try to do the police officer is making a claim that the laws apply to the defendant. He has to go to court and testify. I saw the defendant driving without this. He is assuming that the laws apply. The police officer is openly stating right here. He's stating right here that the defendant was not only subject to the law, but violated them. Now, even in Hawaii, they adopted Rule 602, the rules of evidence from the federal rules. Critics, you can turn around and you can say, oh, they don't have to prove that. The police officer is in court and he's testifying that he violated the law. He's testifying under oath that the law, the Constitution and laws apply to the defendant just because he's physically in Hawaii. Even if he doesn't expressly say that, that's exactly what he's doing when he's saying the defendant violated the law, because it logically follows he's already determined that the laws apply. Now, Rule 602, lack of personal knowledge. A witness may not testify to a matter unless evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Now, you can argue all damn day and say he's only there to testify to the facts, but that is not what a cross-examination consists of. Cross-examination consists of all prior statements. Are they material? Yes, they're absolutely essential to the prosecution's case, even though they don't want to come out and say that. If he's testifying that you violated the law, it's implied there that the laws apply in the first place. If he's going to testify that the laws apply, he has to have what? Personal knowledge, which is why in the Brady request we're asking for personal knowledge. Yet prosecutors or critics mostly think that the prosecution doesn't need evidence of that. Then where's the personal knowledge that the laws apply? It's right friggin' there. It's right there. And the prosecution here had to have known that. Because proving he drove without a license beyond a reasonable doubt is really easy. No one's disputing it. So it has to go to where is the lack of personal knowledge, where is the lack of evidence to prove an element beyond a reasonable doubt? Oh, jurisdiction and the applicability of the code in the first place. Okay, so you also have this. This is United States ex rel Shaw versus Durentis, 755, Federal Second, page 11279. Says right there, the prosecutor violated a fundamental rule known to every lawyer that argument is limited to the facts and evidence. And you want to try to get people to believe that the foundational claim that a written instrument applies to everybody in a certain geographical location, that requires no evidence? Fungal. That's just that is again criminal. That is dishonest to the core. You'll find this on page 1281, by the way. So there, that's pretty damn straightforward. The prosecutor violated the fundamental rule. Let's just blow that part up. So it's really clear here in the video, and it's linked in the article, of course. The prosecutor violated a fundamental rule known to every lawyer that argument is limited to the facts and evidence. Oh, unless, of course, the prosecutor is arguing the foundation of his case, then we'll give him a free pass. Then he's able to argue that God makes it possible for these rules to apply, or this other gross dishonesty that, the people agreed. Yes, that's right. The people agreed. The same people who are forced to pay on the threat of jail are somehow agreeing. Again, my response to that is no, that's just not true. Not true at all. But if you disagree with this analysis and what I've done here, feel free to point out the error of my facts and the error in my logic. And you may do so on a live broadcast of the No State Project. We do 4 hours of live broadcasting a week, and you're more than welcome to call in with that. So I definitely welcome. But big congratulations to Sean for being successful in getting this bogus ticket thrown out with prejudice. Okay, that's a nice one, with prejudice. And I do thank you for sending me the documentary proof of that. It's always appreciated. We'll get it posted here at markstevens.net. Again, my name is Marc Stevens.